Good day, ladies and gentlemen, our esteemed viewers, listeners, followers, and subscribers to Accent Radio. And welcome to another day in classroom, another day with Accent litigation. And I remain your humble host, Barrister David Ono Njoko. And as usual, in Accent litigation, what we do is simplify the law. We discuss law-related issues, whether they are economic related, political, social, sports, entertainment. As long as it has coloration of law in it, we discussed it here, and it has to be topical issues, and that is what we do here. We ensure we disseminate the right information to members of the public so as to cure the malady of misinformation. We don't want a situation where we have a misinformed populate, but we want a situation where we have a population that has a sense of a deep depth of legal literacy. And that is what we do here as our corporate social responsibility, a law asset, courtesy of Accent litigation. Thank you and welcome to another day in classroom. And today we'll be discussing a wonderful and interesting topic, the constitutional issues raised from President Bola Ahmed Tinubu's large cabinet ministers. Constitutional issues raised from President Bola Ahmed Tinubu large cabinet ministers. So many persons wondered on the 21st day of August 2023 that just like Hida Basi broke the Guinness Book of Record of Cookathon, President Bola Ahmed Tinubu decided to break the leadership book of record of Nigeria of appointment-a-thon. You can call it that way. By appointing 45 ministers, it is the largest ever in Nigeria's democratic history since the return of democracy in the Fourth Republic of 1999. Because since 1999, let's go down the history memory lane. 1999, when President Olusegun Obasanjo got into office, he appointed 42 ministers. And upon leaving office as at 2007, he reduced that size to 27. At some point, he ended it at 30 ministers. President Umar Musa Yar'Adua, God bless his soul, when he became the president in 2007, May 29th precisely, he appointed 39 ministers. I did remain so until his death on 5th day of May 2010. President Goodluck Jonathan, upon assumption of office as acting president, he maintained the 39 ministerial cabinets of his predecessor, the late Umar Musa Yar'Adua, and then later on he then appointed 33 ministers, and as at when he left office in 2015, the ministerial list was 37. President Muhammadu Buhari, upon assumption of office in 2015, in order to downsize the cost of running government, he had to merge some ministries, and then he had 36 ministers as of 2015. But upon leaving office in 2019, he had a large cabinet of 42. But despite this, it has never beaten the record of 42 ministers. But Bola Ahmed Tinubu decided to beat the leadership book of record, just like Hida Basi, to beat that record by appointing 45 ministers. Now the question is, in an economy where we are trying to downsize government, is that proper? Is that right? We leave it to the economics to look at the books and then decide if it is right, economically speaking. But here we talk about the law. And so we are going to look at the constitutional issues that this appointment of 45 ministers have now raised. I will look at them one by one. I hope you will follow me in this very journey. It's going to be a small journey, but it will be a very simple one. Number one is the constitutionality of Bola Ahmed Tinubu swearing in the second batch of ministers. Remember, President Bola Ahmed Tinubu sent 2 lists to the Senate. The first list was sent on the 28th day of June 2023, which was exactly 60 days after his inauguration on the 29th day of May 2023. Now, under the Nigerian Constitution, precisely section 147, subsection 3C, it provides that the president shall appoint his ministers within not less than 60 days or within 60 days into his inauguration. So 60 days after inauguration, the president is mandated under the constitution to appoint his ministers. Now, upon the appointment and sending of the names to the Senate, which was initially 28 names the president sent to the Senate on the 28th day of July 2023, which was exactly the 60th day and the deadline of the constitutional window provided. The question now is, the subsequent 19 names, ministerial names that the president sent on the 2nd day of August, 5 days after the constitutional window has been shut against him, are those 19 names constitutionally allowed under the Nigerian laws? Now, it has been argued by some constitutional lawyers that having exhausted the 60-day window provided by the Constitution, President Bola Ahmed Tinubu flouted the said Constitution which he swore on the 29th of May to protect by further appointing 19 more ministers or sending 19 more names to the Senate 5 days after the 60th day of his inauguration, actually on the 65th day after his inauguration. And that has caused some sort of constitutional crisis by some constitutional lawyers as they postulate. Also, some other lawyers who are at the other side, I don't want to call them pro and anti Tinubu, but some other lawyers postulate that the wordings of the Constitution is that the president shall appoint his ministers within 60 days after his inauguration. The Constitution did not say the president shall appoint his final list of ministers for his administration within 60 days. That is to say, within 60 days, the president can decide to send just one name as the list of his ministers. And then he can now send further names after the 60 days. But at least the Constitution provides that he should set up a cabinet. And one person as minister can set up a cabinet. Let's talk about 28 persons as ministers. And as such, the president did not flout any provision of the Constitution, but rather followed it strictly and then exercised his rights under Section 5 of the Constitution, which is to appoint persons that will assist in the execution of executive functions of the president. Now, having mentioned this, we'll now leave it to you, our humble audience, to decide whether the president has flouted the provision of Section 147 of the Constitution for appointing the second batch of ministers 65 days after his inauguration. Meanwhile, the Constitution provided that he can only appoint 60 days within 60 days after his inauguration. Now, the second constitutional issue that has been raised there is that can a president appoint more than 36 ministers? Now, what the Constitution provides is that the president is at liberty to appoint at least one person from each state of the federation as a minister. Now, the question is, having appointed 45 ministers as against 36 states of the federation that we have, has the president not flouted the Constitution by appointing 9 extra names instead of 36, representing the 36 states of the federation? Now, we have to go back to what the Constitution says. The Constitution says at least one person from each state of the federation. That means the president is at liberty to appoint 2, 3, 4, or even 5 persons from a state. But he must make sure that there is no state that should be without a minister appointed by him. Now, having explained this, the president appointing 45 ministers, as long as he has covered all 36 states, or these 45 ministers were picked from 36 states of the federation, has not flouted any constitutional provision, rather exercised his discretion to appoint ministers, at least one from each state of the federation. The next question that we ask, constitutional question that the appointment of the president has raised, is that can the president appoint himself as a minister? Remember, when President Olusegun Obasanjo was sworn in on the 29th of May 2003 rather, for his second term. Upon appointing his ministers, the name of the Minister of Petroleum was conspicuously missing in his list of ministers. And then 5 days afterwards, it was announced that he will be the substantive Minister of Petroleum. Also, in October 2015, when President Muhammadu Buhari appointed his ministers, again, the name of the Minister of Petroleum was conspicuously missing. And then history repeating itself. On the 21st of August 2023, when President Bola Ahmed Tinubu appointed his 45 ministers, again, conspicuously, the name of the substantive Minister of Petroleum was missing. Rather, we had Minister of State for Petroleum, Oil, and Minister of State, Petroleum, Gas. Again, people have raised, is it that President Bola Ahmed Tinubu wants to appoint himself, or has subtly appointed himself as Minister of Petroleum, repeating history which began with President Olusegun Obasanjo in 2003. Again, we'll have to go back to the Constitution. The Constitution in Section 5 Sub 1 provides that the executive powers shall reside with the President, who has the discretion to act directly or indirectly through the office of the Vice President or a Minister of the Federation or an officer of the public service. That is to say, President Bola Ahmed Tinubu, as the Chief Executive Officer of Nigeria, the CEO of Nigeria, can choose to act directly, or can you appoint a medical doctor to occupy the office of the Minister of Information. Also, another key ministry is the Ministry of Aviation and Aerospace. Can you appoint a person who is not a pilot or a professional and expert within the aviation sector to the office of Minister of Aviation? Would that not be disaster in the waiting? Again, we are not looking at the academics. We are looking at the Constitution. So, constitutionally speaking, the President accepts the office of, or the Ministry of Justice. The President is at liberty to appoint any person, as long as the person is from a state of Nigeria, within Nigeria, and is qualified up to school leaving certificate level. The President is at liberty to appoint anybody and assign them to any ministry of his choice. That is the discretionary powers that the President has according to Section 148 of the Constitution. And as such, the dust that has been raised by the appointment of Festus Keyamo, Senior Advocate of Nigeria, who is a renowned legal practitioner in Nigeria, as Minister of Aviation, has raised dust. But again, it is within the discretionary powers of the President under the Constitution to appoint any person as he so desires into such office, except the office of the Attorney General and Minister of Justice of the Federation, which Section 150 of the Constitution has provided that such a person must be a legal practitioner with not less than 10 years practice experience to be appointed as a Minister of Justice and Attorney General of the Federation. That is to say, if the President decides to appoint an engineer as a Minister of Health, or an accountant as a Minister of Aviation, or an accountant also as a Minister of Defense, just as he has done, it can only amount to professional recklessness other than constitutional breach. That is the position of the law. Then we ask the next question, which is, with the creation of new ministries, where would the President get the funding and financing for these ministries? Remember, on the 3rd of January 2023, President Muhammadu Buhari signed into law the 2023 Appropriation Act. And in June, a supplementary budget was sent, or amounted to over 819 billion naira, was sent to the National Assembly for their consent and deliberation upon. Now, both the appropriation bill and the supplementary bill, none of them covers the new ministries that have been created by President Bola Ahmed Tinubu, which are the Ministry of Marine and Blue Economy, and then the Ministry of Petroleum Gas. That ministry is not covered under any of the Appropriation Act, whether the Appropriation Act 2023 or the proposed supplementary bill of 2023. It doesn't cover these two ministries. So where would the president get the money to run and fund this ministry? Or will the ministers be idle and docile until the 2024 appropriation bill is sent to the National Assembly for their deliberation and consent? Now, what the Constitution provides is that the president is forbidden from spending money from the consolidated revenue account or any account belonging to the government of the federation without it being appropriated for under the appropriation bill or a supplementary bill. That is the provision of section 59 sub 1 of the Constitution. Now, the only window left for the president is to send a fresh supplementary budget to the National Assembly, where he will include the ministries of Marine up to 2024. If the president fails to do this, wheresoever the president draws money from to fund this ministry is illegal, is unconstitutional, and it is void. So this sounds as an advice to the president and to those who are around the president, to whisper into the president that the best way out is not to take money from everywhere or anywhere to fund the Ministry of Blue Economy and Marine and the Ministry of Petroleum Gas. Rather, it is to send a fresh supplementary budget to the National Assembly, where you will include the proposed expenditures for the Ministry of Marine and Blue Economy and also the Ministry of Petroleum Gas. Finally, we ask this important question. The appointment of non-indigenes as ministers of constitutional lacuna. Now, we saw for the first time that the Ministry of Federal Capital Territory will be manned by a person not from the southern part of Nigeria. And people have asked, why appoint Barrister Nyesom Wike as Minister of the Federal Capital Territory when he is not an indigene of the Federal Capital Territory or an indigene from an indigenous community in northern Nigeria? Again, it falls back to the discretionary powers of the president to appoint persons as ministers. The president is at liberty, according to section 148 of the Constitution, to appoint any person to any ministry as a minister, as long as that ministry is not the Ministry of Justice. He is at liberty to appoint any person to any ministry and at all. So, for example, Ministry of Niger Delta, the president can decide to appoint a northerner or a westerner, someone from the southwestern part of Nigeria or from the northern part of Nigeria as a minister of the Niger Delta. He is not bound to appoint someone from the Niger Delta region as a minister to mind the Niger Delta. Likewise, the president is not bound or restricted to appoint an indigene of the Federal Capital Territory as a minister of the Federal Capital Territory or a northerner as a minister of the Federal Capital Territory, or simply because the Federal Capital Territory is believed to be situated in the northern part of Nigeria. That is not the provision or the intent of the Constitution. The Constitution gives the president the wide discretionary powers to appoint ministers and assign them to whatsoever ministry he chooses and he thinks that their capacity or they have the capacity to man. Having established this, we have to now come to the conclusion that where we ask the question, what are the criteria for one to assume office as Minister of the Federal Republic of Nigeria? Number one, such a person must be an indigene or a citizen rather of Nigeria. Number two, such a person must have been sponsored by a political party or must be a member of a political party. Number three, such a person must have been educated up to school leaving certificate level or its equivalent. Number four, such a person must have declared his or her assets with the Bureau of the Code of Conduct Bureau and must have sworn to the oath of allegiance in accordance with the 7th schedule of the Constitution. While the first three criteria, which is must be a citizen of Nigeria, must be a member of a political party, and must have been educated up to school leaving certificate level, has been met by virtually all ministers. The fourth criteria, which is that they must have declared their assets to the Code of Conduct Bureau, is yet to be complied with. And this is a clarion call to the president to urge all his ministers to act in line with section 149 of the Constitution, which